Welcome to our Future of Manufacturing series. My name is Emerson Holmes. I'm a partner in the International Arbitration Group at Hogan Lovells, and I'm also sector head of the Manufacturing and Industrials sector. In this series, we have been exploring the key trends that shape the future of manufacturing worldwide. These trends include smart and autonomous factories, the use of digitalization and AI, ensuring sustainability in the face of increasing regulatory and investor and customer pressures, and ensuring organizations are resilient in terms of their supply chains in order to mitigate the effects of any geopolitical and climate disruptions. It is upon reflecting some of these trends that I'm excited to be joined today by my partners Joshua Kurland and Mayur Patel. Joshua and Mayur are partners in our market-leading international trade and investment practice. They are based in our Washington, D.C. office, but they're here in London today. Before we get started, let's hand over to you guys just to give you an opportunity to describe yourself, describe your practice, and where you've come from.
Well, I'm Mayur, and my background was a mix of politics and policy. I was the chief international trade counsel for the Senate Finance Committee of Republicans. So originally hired by Senator Grassley when he was chairman of the committee, and then subsequently Senator Crapo. So my job was to give advice to Republican senators on trade policy, negotiations with the administration, negotiations with our Democratic colleagues. And before that, I worked at the U.S. Trade Representative, where I litigated WTO disputes, worked on trade negotiations like the United States-Mexico-Canada agreement. And before that, I just started off being a commercial litigator for several years.
Joshua.
Well, thanks for having me on. Again, Josh Kurland. My background is as an international trade and commercial litigator. I just joined the firm after 15, nearly 16 years at the U.S. Department of Justice, where I spent most of that time focusing on all manner of trade disputes, anti-dumping and countervailing duties, which folks know as trade remedies, enforcement actions, and then also graduating into administrative and constitutional law issues surrounding the authority of the U.S. president and executive branches in issuing tariffs, enforcing those tariff regimes, and administering those tariff regimes. So nothing that's remotely relevant in today's milieu.
Well, thank you very much for that introduction. It's great to be partners of yours at our firm. And I'm sure you have lots of wisdom in the topics that we're going to be discussing. And looking at it from the standpoint of a manufacturing and industrials sector, the one thing that I've been gathering when I speak to general counsels of businesses in that particular sector, whether that's GC of organizations that are based in Europe, Africa, the Middle East, the Far East, or Southern Asia, is the fact that they are increasingly concerned and have been for a good number of months about what they describe as what's happening in Washington. And when I drill down on that statement with them, they say what is really keeping them awake at night is A, tariffs, and B, sanctions that are imposed by the US authorities. So I thought we would spend the next 10 minutes or so just discussing those two topics. So it's tariffs and sanctions. And if we take tariffs first, Mayur, can you just provide us with an overview of the policy reasons for the tariffs that have recently been coming in to effect from the United States?
Sure. So, I think most policymakers, we like to compartmentalize anything we can, and that's including tariffs. So we think of tariffs in three buckets. We think of it as either a tool of leverage to force someone to get rid of a trade barrier or a political concession. We think of it sometimes as a revenue measure, just to raise money like we did historically. And the third time is protectionism, just to protect industries. Now, I think when you deal with the Trump administration, you can't do those nice buckets that policymakers would like to do. Because the reality is a tariff has all three properties, whether or not you want to use it. And for them, it's meeting all three properties. Mm-hmm. They want all three of them. They're like, hey, this is raising a lot of revenue. It's fixing our budget deficit. Yes, it provides protection. And yeah, it is a tool of leverage because we can dial it up and down to get countries to do what we want. For them, that's kind of the objective here, is to say, look, we think the United States has been fundamentally treated poorly in the world. We've lost leverage. A lot of tools we've used in the past have not worked. Tariffs are pretty good at getting people to give us a phone call pretty fast. And on that, I can't really disagree about.
Yeah.
People are talking to us now, whether this is sustainable, whether this is good economic policy. That decision's going to be a while out. But is it getting the phone calls to adjust things real fast? Yeah, it is.
And what I've noticed is that in the States, there seems to be two avenues of tariffs, if I can describe them like that. The first of which is country specific. So, for example, you hear on the news all the time about the tariffs that have been imposed in China. And only a couple of days ago, we had, I think, President Trump saying that he was thinking about imposing 100% additional tariffs on companies based in China. So that's one bucket. It's country specific. And then we also have particular industries or particular products. And I suppose I have in my mind like the tariffs on aluminium or the tariffs on steel. What's the reason why the administration would go down the country route as opposed to the particular sector route?
Well, the tool for the country is that you want the leverage on that. But the idea was that we have unique problems with each of the countries. You talk about Europe, they don't accept U.S. agriculture. They have a 10% tariff on autos. Vietnam, the issue is that we don't like a lot of low-value manufacturing has gone there, that we hopefully wanted to relocate from China to the United States. Now, the ones that are the large sectors, the administration thinks those are key to national security. So for them, it doesn't matter where it's coming from. It's the problem. But there's also a key point for them that they think that these are the issues where we have what we call the whack-a-mole problem. When we've done tariffs on country-specific, like on steel, it didn't work because somebody else would get their market flooded. Korea says, well, we got too much Chinese steel, so we're going to discount our steel. So the idea was to say, look, this is just a global safeguard for these industries. The issue is once you open the door to national security and think anything's national security.
Yeah, exactly.
And that's what you're seeing happening to a certain extent. You know, you started off with steel, aluminum, and now you've got autos, pharma, polysilicon, and it keeps adding up real fast.
Yeah, that's a great overview. Thanks very much for that, Mayur. Joshua, just a question for you. Can you explain, I suppose, in broad terms, how the tariffs are impacting manufacturing industrial sector and businesses that operate in that sector, first from the perspective in the US and then more globally?
Sure. I think the tariffs affect United States manufacturers in different ways, depending on their role in industry. They're broadly intended, I think, as a main goal to bring manufacturing back to the United States. And so the idea is to encourage companies to do their manufacturing of goods, for example, steel and aluminum, or to rely on steel and aluminum that's manufactured in the United States. Likewise with lumber. Likewise with the country-specific tariffs on, even though they're based on kind of balance of payments issues, the idea is, hey, you should be buying more stuff from us than we're buying from you, right? That's the basic premise of it. So if you're a U.S. manufacturer who is not dependent on imports for your supplies, you might be in favor of these tariffs. Certainly the U.S. domestic steel industry is perfectly happy to have its competitors and the products of its competitors tariffed significantly. Other U.S. businesses are affected in a negative way. Companies that are engaged in importing of their supplies who are subject to these tariffs are paying these tariffs, some of them to a significant degree, and are simply having to live with either taking that money out of their bottom line or passing those costs on to consumers in a way that potentially is difficult for the company. Domestically in America, because we have fairly integrated supply chains in the USMCA region, the US, Mexico, and Canada, there are, I think, domestic companies that are able to take advantage of the preferential tariff treatment that USMCA origin goods receive to mitigate the impact of the tariffs. Worldwide, we're seeing clients affected significantly. Companies who once imported to the United States what are called, for example, steel derivative articles, meaning something that has steel in it in one way or another, as the group of industries or areas, or in technical terms, classifications that are covered by the tariffs are being expanded. More and more companies are finding that goods that they previously imported without any kind of tariff liability or with minimal tariff liability are also now subject to significant tariffs, potentially almost overnight. And so that can really throw companies for a loop. We're also finding that industries that previously didn't really have to worry about tariffs, for example, pharmaceuticals or pharmaceutical manufacturing, other industries that were maybe not an area where there was a particularly heavy tariff burden, are now finding that they're facing these types of duties, and so they're having to adjust to a new reality, and that's changing the business of exporting goods to the United States in a substantial way.
That's really helpful. And I suppose just picking up on something that you said there, Josh, which I thought was quite interesting, is how companies, particularly companies that are based outside the US, are mitigating the effects of tariffs. And I've heard lots of stories from different companies in different settings. And one GC was telling me that they're just hoping to set up some kind of like post box in, say, the Middle East. And they were going to route all of their products through the Middle East to get to the States in order to benefit from the lesser tariffs that's imposed between the States and the UE, as opposed to the tariff rate between the US and China, for example. So essentially this post-box type of arrangement. Is that something that will fly?
No.
It sounded too good to be true.
Look, I mean, you can be creative, but a certain degree of creativity falls into fraud. And this administration, well, I'll let Josh jump in, actually.
So along with the significant ramp up in tariff policy, this administration has made it clear and put resources behind its words that it's going to engage in extremely robust enforcement for tariff fraud, circumvention, and evasion. The U.S. Department of Justice Criminal Division has stood up a unit that is going to be doing, in large part, criminal tariff prosecution, people who they can identify as fraudsters. There was already an uptick in whistleblowing cases, like civil enforcement for under the U.S. False Claims Act. And I think that's going to only increase based on the rhetoric. And I mean, basically, the administration has invited whistleblowers to come forward and blow the whistle on competitors, employers, anyone who's cheating on the tariffs or trying to get around the tariffs in a way that's not permissible. They want to know about it and they want to enforce. Likewise, U.S. Customs and Border Protection it signals that it's going to engage in robust enforcement using their penalty authority. And these are not new issues. And when I was a trade remedy litigator at the Justice Department, we saw plenty of cases of transshipment, which is loosely what you're describing, where a company would send goods through a third country in order to get out of just anti-dumping or countervailing duty, more run-of-the-mill tariff liability. And in those cases, those companies could get in a lot of trouble. There could be significant civil liability due if the civil authorities realized that you were trying to evade duties by rerouting shipping. The touchstone in U.S. trade practice generally is this concept of substantial transformation. It means some different things in different contexts. It helps to have a good lawyer who can work through these issues with you, and I suppose that's part of what we're here for. But the basic premise is that the product that you're importing, in order to become a product of country A, whatever country that is making its final trip to the United States from, it has to be transformed into effectively a different product, changed in such a substantial way that you would say this is no longer a product of, say, China, but it's a product of the country that it most directly came from. Without that kind of substantial transformation, companies are risking, particularly in this environment, significant enforcement actions, including in the criminal realm.
So what's meant by substantial transformation then? Is there some kind of like test guidance that's been issued by whether it's the DOJ or the courts?
I mean, it's basically the character of the product has changed into a new product.
Right.
I mean, there's minor things you can do, and that product hasn't changed its character. If I take a jalapeno and just cut off the stem, it's still a jalapeno.
Yeah.
Hey, I make a new entree. You've got a new dish here. Maybe mix it in with some soup, cook it. Okay, we might have a different product. And that's kind of substantial transformation works. Are you in one tariff line, and have you moved into a new tariff line because of what's been done to it?
Right. I get you. And has there been lots of litigation about this? Have you heard, I suppose, on the grapevine that the DOJ, the criminal division, have targeted certain companies who might be trying to evade the tariffs by looping through different countries?
I think it's too early. I mean, there haven't been prosecutions yet, but it's very clear that they're looking to identify companies who are engaged in tariff evasion, presumably to let the world know that if you engage in this type of evasion, there are going to be significant consequences. I mean, again, it can be civil as well as criminal. I think that there's a typical definition of substantial transformation that are employed by U.S. Customs on the one hand, the U.S. Department of Commerce on the other hand, and I think the issue is not that they have specific companies in their sights, or at least not that we've heard, but that if they get a whiff that someone is kind of engaging in, I guess cutting corners, that they are prepared to enforce.
Brilliant. So the other thing, again, when I'm speaking to general counsel of companies in the M&I sector, they're saying, well, look, we're exploring the possibility of setting up a new manufacturing facility in the States. Let's just say, I don't know, in Wyoming or something like that. And they say to me, well, it's going to take years. It's going to take years in order to finalize the design, get the necessary permits, construct the facility as well, employ the right people, etc. And this could be 3 years, it could be 5 years. And they don't have any certainty that the tariffs will be still in place in 3 or 5 years, whether that's because of the recent court case, which I think is before the Supreme Court, which, Josh, I think you mentioned earlier, or whether it's because Congress may flip in the next midterms, or indeed there might be a new president at the next elections. Do you have any views on whether the tariff policies are likely to change in any of those situations?
I don't see in the short term, and that means a few years, at least till 2028, but even a little beyond that for the tariffs to go away. I mean, look, if these tariffs are struck down by the courts, there are other tariff tools that they will use. But it kind of goes back to that original point I made. There's a revenue component too, and it's really attractive. That's something we just can't. We're government. We get addicted to money real fast.
Yeah.
You put taxes on cigarettes, you hope people don't stop smoking.
Yeah.
But I look at Trump 1, Biden didn't take away those tariffs. And I think that's one of the elements here, that even if they wanted to, they'd say, well, wait a second, we're getting revenue. And then now we have all these people who are benefiting from the tariffs protectionist industries. It'd be politically difficult to unwind it. It would take us years. So I think that's something that we'd have this challenge with. If we were to unwind it, we'd tell countries, okay, then you're going to have to give me something for it.
Right.
So it's going to be difficult to unwind this in the short term. There's one other thing I just kind of flag. For Trump land and the Democrats, they believe in industrial policy, but they have two different views. For the Democrats, it was the Inflation Reduction Act, subsidies for green industries. For the Republicans, it's tariffs. But the Republicans think the tariffs work better as industrial policy because it's harder to remove, just because it gets so much political popularity. Right. And I think that's something that's absolutely true.
Right. Josh, have you got anything to add to that?
Well, I would just reemphasize what Mayur said, and this is the point I was alluding to earlier, that regardless of what happens at the U.S. Supreme Court with the IEEPA tariffs, there are other authorities that the president can rely on to continue to oppose tariffs. For example, we saw just a few weeks ago that the president imposed tariffs under the Section 232 authority against lumber, or at least the national security nexus is kind of the lumber and forestry industries in the United States. But we saw that those tariffs that he imposed extended to things like upholstered wooden furniture, kitchen cabinets, other things that are made out of wood that the president then tied to the idea that we need a thriving wood and lumber industry. And so even these products that are not traditionally considered national security products fell within the purview of these tariffs. That's an example of why there are other authorities that the president can turn to enact potentially fairly broad tariffs, even if the IEEPA tariffs are struck down by the Supreme Court. So that's a long way of saying, I think Mayur's right that these tariffs are going to be with us for a while. And clearly the encouragement is to move manufacturing to the United States. It's not the only thing companies can do, and particularly as some of these trade agreements have shaken out and the president has struck deals with different countries. I think companies that are nimble and able to think about their supply chain can also, and with the right advice, look at ways to mitigate their tariff situation. There may be a product that you need to import for your supply chain that you can get from the UK, which is subject to a 10% tariff, as opposed to the EU, which is a 15% tariff, as opposed to other places, which are larger tariffs. So companies do have the ability to think about these issues in a way that is smart. And of course, it depends on the specific facts of a company. I understand that manufacturing isn't necessarily something that can be moved easily. At the same time, I think there are opportunities for companies to work within the environment and improve their situation.
Great, thanks very much for that. We've touched on about penalties, and I think, Josh, you mentioned that there is civil and criminal penalties that the DOJ could utilize in certain situations. I wonder whether you could just develop that point a little bit. And I suppose what I have in my mind is, obviously you can have civil penalties against companies, fines, I'm assuming. In terms of criminal penalties, are you there talking about criminal liability of directors of companies who are trying to evade tariffs?
Yeah, I think the short answer is yes, potentially. It is not uncommon on the criminal side for the Justice Department to pursue cases against individuals when the evidence supports a case against an individual. But often it is easier criminally to pursue a case against a single individual, an officer or director who, in the view of the authorities, has been engaged in malfeasance.
And what range of penalties are we talking about in terms of financial? Are we talking about a percentage of a company's revenue, or a estimate of the amount of tariffs that's been evaded by trying to circumvent the regulations?
So on the criminal side, it's really more about people losing their freedom than
it's jail, is it?
Right.
Potentially.
It can be. I mean, there have been people sentenced to jail time.
Right.
I mean, I'm not saying this to scare people. I mean, but people have to be conscientious, right? Yeah. On the civil side, the two authorities we think about are False Claims Act liability and liability for customs penalty. Under the U.S. False Claims Act, the damages can be the touchstone is treble damages. So the damages can be triple whatever amount of money, and in this case it would be like the amount of tariff revenue that was withheld from the United States government. On the customs side, the touchstone is for there's kind of negligence, gross negligence, and fraud are the three levels of penalties. Fraud is kind of its own sui generis thing, but at the negligence and gross negligence level, the penalties can be 2 times the duties or 4 times the duties. So there are significant penalties. What the upshot of this is for companies is that companies really need to have robust insight into their supply chains, right? Companies need to have robust compliance programs where they're in touch with their suppliers. They really understand where it's coming from. They understand whether the goods are being substantially transformed. They can get a legal opinion on that. It also affects the contractual relationships, both because from a dispute settlement perspective, it's useful to have relationships that allocate these risks for tariffs. But more importantly, companies can negotiate agreements with their suppliers to, for example, provide a robust paper trail documentation of where their goods come from, or to agree in advance that they will cooperate and assist with any kind of audit that occurs as a result of enforcement steps that are taken by U.S. authorities. And so having that visibility into the supply chain and having those contractual agreements in place that allow you to provide the authorities the information are probably the best way companies can protect themselves against enforcement.
Thanks very much for that, Josh. That's a huge amount of thinking that needs to go on within businesses now, and processes that have to be put in place in order to try and mitigate the effects of tariffs. Well, what I wanted to do in the time that's remaining is just touch upon sanctions. And again, speaking to clients in this sector, they're concerned about sanctions, and in particular, sanctions that have been imposed by the US authorities. And I'm just wondering whether you could just provide a bit of an overview. I'm sure it's a very complicated area, but a bit of an overview in terms of what the sanctions regime looks like in the US.
Sure. So, I mean, a lot of our sanctions are run by the Department of Treasury. I mean, there's a different set of like export controls and things like that. But if you're thinking like, okay, there's some war in Ukraine and there's lots of sanctions, Treasury maintains an office, the Office of Foreign Assets Control, and they manage a lot of the sanctions policy in the U.S. So, I mean, that's the 30,000-foot level on that.
Yeah. And you, in the US, you designate particular companies and particular individuals.
Yeah, and sometimes countries too.
Right, and country like Iran, for example.
Right,
or,
right. So I think that's sometimes the trick is that you'll say, wait, this company is, in Vietnam. Why is it? But they're like, oh, it's an affiliate of this Chinese company, so it's sanctioned. So that's the trick about this thing. And it's expensive from a compliance perspective. It's important, but it's a challenge.
And again, looking at it from the sanctions perspective, you as a company have to, as it were, screen your supply chain as well, do you? I call it X-raying your supply chain in order to make sure that people within or entities within your supply chain have not been sanctioned. Is that how the US approach it?
Yeah, I think to me, like I had a former colleague on the other side of the aisle who I love, but not very sympathetic on when I say, look, it's tough on compliance costs. Can we find ways to be, you can't expect everyone to know everything. I was like, the US government doesn't know where it gets supplies. And her view was, there's no right to engage in international trade. Lose you some money. I don't care.
Right.
She's like, if you have to eat money, if you want to engage in business overseas, that's your problem. I don't want you to engage in that. Now, that was just her view. Now, like I said, I thought that was a little unreasonable.
Yeah.
But her view is shared by a lot of people. And that's the position on these things is, hey, you are responsible. If you want to do business in these places.
Yeah.
And I think to me, the challenge is people can be doing business in a lot of great places that are reputable, good rule of law.
Yeah.
But they may have a different foreign policy position in the United States. So you may not necessarily know that this company that's operating there is under a sanctions regime.
Right. And has there been a shift in terms of the approach to sanctions between the Biden administration and the Trump administration?
I think that there is one element, which is that we're using tariffs where we would use sanctions.
Right.
We can discuss whether or not, people think what we've done on India with the tariffs or Brazil, but these are national security actions. And we said, oh, well, we're just going to hit them with a tariff instead of a sanction.
Right.
And like I said, the verdict's still to be out, but in a way, it's gotten more attention and more dialogue than this. I mean, we have so many sanctioned entities. We've been, remember when Biden said we were going to sanction Russia in a way that it's never been sanctioned before, and economy is going to go bankrupt.
Yeah.
Hasn't quite happened. But people are talking a lot more on the tariffs here, and I think that's something to think about is, yeah, they'll continue to use sanctions, but in a way, it's easier for the United States because the good can still come in.
And they get paid.
And you get paid.
And the US Treasury gets some money.
So, the guy who's completely out has no incentive to do work with you. Now that he's like, well, great, I'm going to call this government too and say, you better make a deal because I'm losing a lot of profit here.
Yeah, exactly.
I think it's important to note that there has not been much shift in the sanctions landscape between the Biden and Trump administrations. Yeah. So we have kind of two or three types of sanctions. We have country-specific sanctions against, the typical countries you hear about from the United States perspective: Iran, Cuba, North Korea. The Syria program was actually the one exception where the sanctions have been rolled back, given the changes that have occurred in the regime there. And then very extensive sanctions in the sense that there are different kinds of sanctions in the wake of the Russia-Ukraine war against Russia and Russian interests. Those have not changed. Even the Russia sanctions have not changed significantly as a result of the change in administrations. And some of those regimes, particularly, for example, the Iran regime, involve secondary sanctions as well, where you can have, they're kind of fact specific. So So I'm not going to try to lay out all the scenarios here, but you can have scenarios where companies, for example, here in the UK, may not necessarily be touching the U.S. in a specific way, but still be subject to U.S. secondary sanctions or secondary sanctions in the EU or the UK as a result of their activities. So it's important for companies to be aware who they're dealing with and what the sanctions implications of that are. Sanctions run by the Office of Foreign Asset Control is when there's a particular country and you're not allowed to do business with that country in any way, shape, or form. Those are kind of like the Iran sanctions, the Cuba sanctions. We also have export controls and what are called entity-listed entities. This is run by the Department of Commerce Bureau of Industry and Security, controls dual-use technology, as well as various sanction regimes. Several of the Russian sanction regimes as well are under their authority, for example, Russian industry sector sanctions. And there are entities that are listed as being prohibited entities or ones that require a license to do business with them. Just a couple weeks ago, the Bureau of Industry and Security rolled out its new affiliations policy, which mimics the policy that OFAC has had for hardcore sanctions for some time, which is that entities that are essentially 50% owned by someone who's on the sanctions list, the so-called entity list, are now also subject to the same license requirements and sanctions. That's a big change. I mean, it's not different than how it's applied in the OFAC context.
We talked when we discussed about tariffs, about the sanctions and enforcement and that sort of thing, and what penalties, both civil and criminal, can be applied in the event that you try to evade tariffs. What's the position regarding enforcement in the sanctions setting?
Similar. You could go to jail. If it's they find that you're willfully evading sanctions, there could be jail time.
Right. And fines, etc.
Fines, all the fun things that you hope you never really have to encounter in life.
And again, do you feel as though there's been a bit of a shift in the enforcement, I suppose, rigor in the Trump administration as opposed to the Biden administration, or is it too early to make a judgment on that?
I think on sanctions is a little too early to tell. I think on tariffs, that is a priority. They said, look, we've done this, we know. But also, I mean, for years, one thing I'm finding a lot is people were not classifying their goods properly for years. Like, it's just something I've noticed over it. And I was like, nobody cared when it was zero tariff versus zero tariff. You're like, USB cable versus optical receiver. Nobody cares. It's 0-0.
Yeah.
Now it matters all of a sudden.
Right.
And that's, I think, the challenge I think we have to think about is, and now because there's a difference, you may get in a world where you may have an issue of like, hey, there's going to be penalties kicking in here.
Yeah.
The things that you thought you were fine for years because nobody cared, now they are.
So it seems as though everything's changing in the States, both in terms of sanctions and also tariffs as well. So for companies that are operating in the M&I sector, it's something that you need to keep on top of regularly.
Yeah, I mean, one thing that I thought was kind of fascinating is, when Trump put his first tariffs on Canada and Mexico, everybody is running down the hall freaking out. We're like, what do we do? What do we do? And I was like, well, we've got a free trade agreement. Those goods are qualifying. And then we checked, only 30% are claiming the free trade's benefits.
Right.
And the reason was, they're like, I didn't bother to because it was zero anyway for half these goods.
Yeah.
Why would I keep the paperwork for a free trade agreement to say like where it was processed and this? And now you do. And I think that's the challenge. We have more compliance. There's still benefits to be done there. There's lots of opportunities in this crazy world we're living in. But yeah, I think we have to double cross all our T's and double check our I's.
Yeah. Josh, do you have any concluding remarks on this from an M&I sector perspective?
I think that the M&I sector is probably, out of any sector that we deal with here at Hogan Lovells, the one that is kind of most affected by the changes in U.S. tariff and sanction policy. And so for better or for worse, it's been a good time for us to be coming out of the government and joining the firm because there's plenty of work for us to do. I think the thing that companies need to do is if they're unsure, if they want to make sure they're engaging in compliance and mitigating their risk, is being consulting with counsel, making sure that they have a firm legal basis for things that they're looking to do. My touchstone is if it seems sketchy, don't do
probably
it.
is.
It probably is.
Yeah.
Talk to someone about it.
Yeah.
But even if you're not in kind of that kind of comical realm,
Yeah.
I think you want to be in a position where you're working with counsel to understand how things are developing and making sure that you're staying on the right side of it. And that's the way companies are going to succeed in navigating this more fraught environment.
Brilliant. Thank you very much indeed. I know you're very busy whilst you're in London, so thank you very much for sparing some time for this
pleasure.
discussion.
Thank you.
Thank you.